Audible?
Yes.
Yes, sir.
Yes, sir.
Am I visible?
Yes, sir.
Yes.
Sir.
All right. Good morning, everyone. Hope you guys are doing well.
Good morning.
Good morning,
Morning,
sir.
sir.
Let's get started with quick revision of whatever we've discussed so far. All right. And we may be in a position to wrap up this chapter in today's session. Now, before I begin, Sunday mornings, most of you have been kicked out of your bed, all right, to somehow open your laptop and go ahead and attend the session. It's worth it, guys. All right. The whole effort that you're putting in, trust me, is worth it. I had one of my students, all right, back then, probably 2-3 years back. He comes from a background where not sure that he is going to get the evening meal or not. Am I audible to everyone?
Yes,
Yes,
sir.
sir. Yes, sir.
All right. Not sure that he is going to get an evening meal or not. Worked hard. When I say worked hard, if you and I can put 7 hours to do something, he's going to put 12 hours to do it. Worked extremely hard. Two reasons. One, coming from a background where he had throughout his journey studied in Kannada medium, all right, and thereafter picking up a language which is from ICI is slightly technical. We'll not deny that, all right. ICI is maintaining their standard. You and I would have taken 7 hours to finish a particular chapter. He used to spend 12 hours to do that. I remember him mentioning in one of the sessions in the pass out meet after clearing. Nobody talks about their journey during the sessions. All right. So it makes sense, right? You would want to listen to somebody who's cleared it, not somebody who has been writing exams for ages and not clearing. Everybody wants to listen to success stories. Nobody wants to talk about failures. I'm not sure how many of you can make sense out of it, but this is the bitter truth of life, bitter reality of life. He comes in the pass out meet. He says, sir, there were days when the drainage next to our house used to open up because of high flooding. And at times that drainage water used to seep in through our house. So sitting in that dirt and studying used to be a task for us. But somehow the necessity at home, somehow that pressure at home, somehow the life really wanted me to go ahead and take that extra leap. Successful chartered accountant today, working with Infosys. Each one of you have your own ifs and buts. Everybody, all right? Everybody have their own ifs and buts. You have to get out of those ifs and buts. All right? Who is that person? Why is that person? Let's not break our head. The point is, there are so many people who are having their own issues. You might not even be aware of who is the person on the other side. He might have his own, she might have his own, her own issues. But getting out of that is equally important, because nobody really wants to sit and listen to your dukh bhari kahani. All right, nobody really wants to sit and listen to your sad stories. Whether you've achieved anything after that is what we are going to talk about. I'm not talking about some student who has come from a lavish lifestyle and become a chartered accountant, right? That will not even inspire you guys, because that is bound to happen. But somebody coming from nowhere and today being there in one of the biggest listed companies of the country is not a small talk. Guys, each one of you come with your own baggages. Don't discount that baggage. All right, I'm not sure what background each one of you come, and neither I'm interested. Nobody is interested in listening to your issues. How far have you made it even after those issues? makes a lot of difference. The person at home, all right, both your parents, mom and dad, most of the time, their efforts are taken for granted. But a reality of life again, all right, this is how we are made up, and there's nothing wrong. It is something that we picked it up from our ecosystem. Our parents may not tell us what they would have gone through the whole day to ensure that you are sitting peacefully for 2 hours right in front of the system, listening to somebody talk to you about them. Please start valuing. It's not a small thing. If you were to ask to do something for your parents, you won't do it. If you were to ask something to do for your own siblings, you may not do it. But those guys are selflessly doing it for you. Start respecting, start doing it. All right. Now, how you do it, when you do it, what you do it, you're all smart enough. You really don't need a teacher who's going to give you guidance on what you need to do. You're smart crowd. All right. Let's accept that the current generation is the smartest generation. But at the same time, the problem is it is the laziest generation as well. Not your mistake. It's the environment which has made us. We never asked for it. You come in that setup where things have gone a little haywire. Pick it up. Please start working on your career. Nobody is really interested on knowing how many attempts you have written. Everybody is interested whether you become a chartered accountant or not. Am I clear? Not sure how many of you can make sense out of it. I happened to meet somebody yesterday in the evening, and that's when it just flashed to me that you and I are in a very comfortable zone, guys. Let's accept it. All right. The fact that we both are sitting right opposite our screens, in front of our screens, is the testimony to the fact that we are in a very, very comfortable zone. That person was just telling me, again, happened to come over a conversation, and that's exactly when I picked it up. All right. That person's who it is, why it is, when it is, let's not break our head. Engineering student, father is an auto driver. All right, with due respect, somebody's profession, absolutely fine. All right, father is an auto driver. He says, sir, my father at least works, he ensures that he takes up half an hour extra auto services in the evening, so that even if there is that one extra ride, he can make it up for my evening meal peacefully. Each one of us, to that extent, are at least comfortably positioned. Your parents are not going to ask you 100 things. All right. The best part about our generation is our parents have given up on us. They are very clear. I am not expecting anything from these kids. At least let them do something for themselves, not for us. You go ask your parents, what do you expect from me? They will tell nothing. Genuinely, please go ask your parents after the session. Just take split seconds and ask them, parents, what do you really expect from us? Law I will cover. You don't have to worry. Syllabus, those of you said, sir, on a Sunday morning, you don't give this gyan. My headache to finish the syllabus. And you, by now, you should have got to know I will not compromise on the quality. All right. But having said that, go ask your parents, what do you really expect from us? The first thing they will say, nothing. Because they know they will not get anything. But at least let us do something for ourselves. And what you're doing right now, sitting in front of the system and listening to me, Sunday morning, somebody giving you extra gyan, which may not even be relevant, something that you're looking for, can't help. All right. What you're doing right now is not for them. You're doing it for yourself. So stop living in a zone where you're trying to prove that I'm doing for my parents. No, you're not doing anything for anyone. You're doing it for yourself. After the session, just take 5 minutes. Ask your parents, what do you really expect from me? The first answer, if you do not get nothing, then you have to introspect. Genuinely, the first thing your parents will say, nothing. So those of you who are getting up at 6:45 in the morning, listening to a theory class on a Sunday morning, you're not doing for anybody. You're doing it for yourself. So stop sympathizing your situation and living in a thought process. What is my life? This life you've chosen, live it to the fullest. And the fullest that you can do right now is give your heart and soul wherever you are. As simple as that. All right. Too much for the day. All right. So don't worry. Here and there, I think, chartered accountants, each one of you will pick. I'm telling you, assuring you that with a little extra effort, each one of you will become chartered accountants. But guys, uh, equally important to be human beings. Good human beings also, I'm not asking. All right. Let's just have that basic humanity. We've lost it. Unfortunately, we've lost it. Not you, including me. All right. The generation as such is losing it. Let's not miss out on that. All right. And I assure you, being associated with CAPS for now almost, I would say, more than 1.5 a decade, we are not here to cover syllabus. We will cover it. We are not here to make the best chartered accountants. That you will do it with a little extra efforts. We will be there, the torchbearers. We are going to help you in guiding your paths. But at the end of the day, each one of us have that onus to make a better society, not just for ourselves, but for somebody who is actually putting in a lot of efforts behind the scene. It is what it is. Let's get started with our session. All right. So we are going to wrap up the chapter called incorporation. How much of importance is there? We've already discussed. We'll quickly revise. I'm not sure how many of you noticed I've not started a single session. Now it's been 3 sessions at least with me. Not a single session I would have started without revision. It's not about me. It's about the fact that you have to revise law every now and then to remember it. I have been teaching law for close to 8-9 years now. All right. But still, even today, before starting a session, I make it a point that I go through law and then sit with you. Now, it's not about memory. It's about ensuring that you know what has changed, ensuring that you know what needs to be picked up. Not sure how many of you can make sense. So please make sure that when you're preparing for your examination, you read and ensure that you keep revising it. Only then law will become a cakewalk, or else it's going to be a task. I know students who have got 70 plus in other subjects, 38 in law, out. They had to come back. Making sense, everyone? All right. So please note, law can become a make or break paper if you don't put in the efforts at the right zone. Clear, everyone? All right. So let's get started. Let's quickly revise whatever we've discussed so far, and then we begin with today's session. Is the screen visible to everyone? Yes.
Loading. Yes, sir.
Loaded?
Yes, sir.
All right. Interesting saying, but quite a lot of sense in it. Every morning, even now, you have 2 choices. You can continue sleeping. I am not going to really count number of participants and all of that. That's your headache. You can continue sleeping, or you can actually pick up your chase of dream and chase it really bad. You have both the options. You decide what you want to do. All right, let's get started. Now, let's quickly revise. Is the screen visible to everyone? Yes.
Yes,
All right.
sir. Yes, sir.
Topic that we were discussing was incorporation and formation of company. We went on to understand what exactly is the definition of the word promoter. We saw a couple of examination questions. We saw the concept of formation of company under section 3, subsection 1, which talks about types of company based on number of members. Then we went on to understand what is the concept of OPC under section 2, clause 62. Is the screen visible to everyone? Yes.
Yes, sir.
What is OPC? How many members can I have? What is the concept of nominee? What will happen in case of the nominee? Who can become a nominee or a person? All of these covered as a part of OPC. We went on to understand how a nominee works, who's going to give the nomination, what is the form that you're going to file, Tanya. We went on to understand what exactly are the questions that are revolving around OPC. We saw the concept of private limited company. We saw the concept of types of company based on liability. Then we went on to understand what is unlimited company. We saw the concept of private companies under section 2 clause is 2 clause 68. All right, RLP. We went on to understand how the calculations happen. What is public company under section 2 clause 71? Public company means a company which is not a private company. Proviso becomes extremely important, wherein the deemed public company concept comes into picture. There is one question. All right, I've skipped this with conscious efforts. We're going to look at this after the entire chapter. All right, what is that slide? We'll look at it later. We came to the concept of small company, where we saw the number has been updated because of an amendment. Now it is 10 crores and 100 crores. All right, paid up share capital and turnover. Then we went on to understand subsidiary as a concept. Subsidiary means a company which is either controlling the composition of the board of directors, another company is controlling the board of composition, and the other one is exercising more than one half of the total voting power. All right. One half does not mean one and a half. It is one portion of the total, which is half. More than 50% is what we are trying to say in more than one half. All right. Together at its own or together with one or more of its subsidiary. Associate company is a company in which another company is having significant influence. And how much is that significant influence? At least 20% of the voting power. We saw a couple of numericals. We went on to understand section 3A, which talks about members' liability. We saw section 4, what is MOA? What is the definition of the word MOA? How is it a public document? And then we went on to understand what are the details to be mentioned, or what are the details covered in MOA. No clause, name clause, object clause, capital clause, liability clause, association clause, situation clause. Then we went on to understand three doctrines: doctrine of ultra vires, doctrine of constructive notice, doctrine of indoor management. Section 5 talks about articles of association. Very important concept in articles of association is entrenchment of articles of association. Is the screen visible to everyone? All right. Entrenchment of articles of association, which talks about making the law stricter for yourself. How do you do it? In case of a private company, unanimous resolution, all the members have to agree. And in case of a public company, special resolution has to be passed. What are the formats of your MOA and AOA? MOA is given in table A to table E. AOA is given to table F to table J. Sir, why so many tables? Because it's a different type of company. You have a different type of format. It can be a company limited by share. Close all your books. Close all your books. Complete focus on screen. There's a reason why presentations are made on screen. Next, we went on to understand, can the MOA, AOA, and any of your resolutions, contracts override the act? Answer is no, it cannot. If it does, I will consider it as void. We went on to understand the concept of, this is an example. All right, we went on to understand incorporation as a concept. We saw how an application will be made. How are you going to look at it? What is the mechanics for incorporating a company and the types of forms that you're going to file? This is about your incorporation. We saw on the portal how incorporation works, which is called as run, reserving your unique name. How long do you reserve it? What can happen? All of these were a portion of my incorporation pointers. Then we went on to say, once you are incorporated, what will happen? All the features of a company will get generated. All right, whatever features that we've spoken about, legal person, separate person, you can go ahead and a company can purchase shares, all of these, or people can purchase the shares of the company. All of these are covered under section 9, which is nothing but the features of a company, which we have discussed earlier. Then section 10 says MOA and AOA is more like a contract, all right, wherein the company is bound with the outsiders and members are bound with the company. This is more like a contract. Section 10A says, just because you have got a certificate of incorporation does not mean that you can go ahead and commence your business. You have to give declarations, 2 declarations. What is the declaration, Chandana? The first one, every subscriber has paid the value of their shares that they have agreed to take up, and my office is verified. This is coming within a declaration. Within 180 days of my incorporation, I have to give this. Then we went on to understand registration, registered office under section 12. Every MOA will have the state in which your registered office is to be given. All right. Should I have an office at the time of incorporation? Answer is no. But however, within 30 days of your incorporation, you must have a registered office set up. Can I change my registered office later on? Answer is yes, by filing a form called as INC 22. Now, labeling. If you recall, this was the topic where you had picked up a couple of products around you and saw how the labeling is done. All right. Now, when it comes to labeling, we are giving the details of the company. What all are you going to capture? Name of the company, SIN, number, fax, email ID, website. All of these are going to be captured. Where is it captured? It is captured on the nameplate. It is captured in the seal. It is captured in the invoices, bill heads, business letters. Everywhere you're going to give the details. Next, whenever the company's name has changed under section 12, subsection 4, every company has to give their current name as well as the former name. All right. For how long should I give the former name? You're going to give it for 2 years. This is about your changes in name. Next, we went on to understand alteration of MOA and AOA. Section 13 says, whenever you want to alter your MOA, pass a special resolution, and wherever required, I will tell you that you will have to take the central government approval as well. Example, if I want to alter the name clause, I will have to pass a special resolution and central government approval will come into picture. Public to private, private to public, I don't have to separately take central government approval. Reason being, I would have taken it as a part of my conversion itself. Then we went on to understand object clause. In case if I want to alter my object clause, law says no problem. You can alter it by passing a special resolution. But wait, when you've raised money from public by issuance of prospectus, all right, in that case, if you've raised it for a particular project, then you have to use it for that project itself. No, sir, I want to alter the project. Then in that case, you have to pass a special resolution. English, or you have to provide the details of the resolution passed in the newspaper. Dissenting shareholders will be given an exit offer. All right. Whoever is not agreeing, they have to be given an exit offer. Do you remember in yesterday's session, we spoke about an exit offer as well? All right. This is about alteration of object clause. Liability clause, in case if you want to alter, again, a special resolution, nothing significant. Capital clause, if you want to alter, special resolution, wherein I'm altering the authorized capital. Subscription clause or association clause, in case if I want to alter, again, a normal special resolution will be sufficient.
Cannot be
Clear?
altered.
Why it cannot be altered? What example did we take?
Neil Armstrong, first person to land.
First person who landed on moon. Can that change for your parents? Answer is no. Can it change for you? Answer is no. Can it change for your kids? Answer is no. The answer remains the same. The same way the first shareholders of the company also cannot change. It remains the same. Sleeping?
No, sir.
No, sir.
We went on to understand what exactly will happen in case if you're changing your registered office. Within the city, in case if I'm changing, pass a normal board resolution. Open your eyes. It's not special resolution. It is board resolution. I don't need members. Why? Because I'm within the city itself, sir. From one area to another area within the city, if I'm moving, I don't need shareholders approval. I can take my own board approval. So board resolution is sufficient. And then you're going to inform the registrar. You are not going to alter the MOA. Very important. From city to city, if I'm passing, moving on, special resolution will come. However, AOA or MOA need not be altered. From state to state, if I'm moving, then I need special resolution. I need central government approval. I need alteration of MOA, and a fresh certificate of incorporation will be given. The last one is ROC to ROC, where I'm moving from one daddy to another daddy. Example, Maharashtra, where there are two registrar. Tamil Nadu, where there are two registrar. If I'm moving from one registrar to another registrar, then in that case, special resolution, and very important, granddaddy, which is your regional director's approval is required. Alteration of MOA may be required in case if you have specifically mentioned about who is your registrar. Next, alteration of articles of association. Simple. Whenever you want to alter your articles of association, pass a special resolution and you can go ahead and alter. Rectification of name. Section 16. First case, if your name is identical with that of another company, all right, in that case, central government can go ahead and pass a direction, and within 3 months of such direction, you will have to alter your name. In this alteration, do I need a special resolution? Answer is no. Ordinary resolution is fine. Why? Because central government itself is asking me to change. I don't need 75% approval from the shareholders. Ordinary resolution will be sufficient. Manasa, clear? Next, we went on to understand what will happen in case if there is a registered trademark. All right. If your name is resembling the registered trademark of another proprietor, law says that other proprietor can make an application within 3 years of your incorporation to the central government, asking the central government to give the direction. 3 years. Clear?
Yes.
100%. Everyone understood? Within 3 years of the incorporation of the company who has gone ahead and copied the registered trademark, your incorporation in our example, they can go ahead and ask you to alter the name. Central government will give you certain direction, pass an ordinary resolution and go ahead and alter the name. Open your eyes. Here it is not special resolution, it is ordinary resolution. Next, copies of the MOA and AOA. In case if any of the members are asking for a copy, you have to give the copies of your MOA, AOA or any other agreement. Very important, sir. If I don't give a copy to any of the members, then in that case, the company will be in default, penalty of 1,000 rupees each day, which can extend up to 1 lakh rupees. We went on to understand section 18, which talks about conversion of company, private to public, public to private, section 8 to any other company, OPC to public or private company to OPC, and section 8 to OPC to section 8 company. All these 6 cases we have discussed where the conversion is allowed. Crystal clear, everyone? Yes.
Yes,
Now
sir.
quickly slap yourself. Those of you nodding and saying yes, slap yourself. Quick, 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 quick. Those of you said yes, slap yourself. Sunday morning, let's feel ourselves is not this session about. Quickly slap yourself. OPC cannot be converted into section 8 company. All right. I hope I am clear. OPC cannot be converted into section 8 company. Just in the flow, you have to be very careful with me. Huh? Just in the flow, I will bring in something, and in case if you're sleeping, you will continue sleeping. This is not allowed under the law. I hope you remember. That's why case 6 comes in later on. This is not allowed in the law. If you remember when I was discussing OPC, OPCs cannot be started as a section 8 company. If you remember, understanding everyone? All right. Next, we went on to understand, or rather, we are going to begin today's session on this note. Yesterday's class, I'd left you guys with a question. Anyone? What was the question?
Can subsidiary company hold shares in
What was the question that I had asked?
Can we
Can
decide
we decide our parents' career?
That is the question. All right. Can you control your parents other than emotional drama? Can you control your parents? Emotionally, you can go ahead and control the entire world. All right. That's what Trump is doing right now. The point is not that. The point is emotionally leave it. But otherwise, can you control your parents? Answer is no. That's what we are learning here. Important topic. All right. How do you go about and control the parent itself? You decide your father's career. Wow. Flip. Your father deciding your career is still acceptable to an extent. You decide, my father should be an engineer. What is he doing sitting as a mechanic there? All right. Or my father should be an engineer. What is he doing as a chartered accountant there? Have you ever, anyone sitting here has decided? Meet me personally if you've done that. All right. How do you do it? I don't know the mechanic. Let me know how it works. Coming back to the point now. Sit straight. Similar lines. Section 19 also says. Sit straight. I'm starting with today's syllabus now. 100% focus. All right. Section 19 says a subsidiary cannot hold shares in the holding company. Why? The moment you start holding shares, you will start voting. At the end of the day, shareholders vote. Correct? Now, if you're holding shares in the holding company, you will start voting in the holding company. It's as good as the child deciding for the father. That's what is going to happen. Everyone with me? All right. So section 19 is very clear. I don't want a reverse flow. Law is very clear. Subsidiary cannot hold shares in the holding company. Clear, everyone? First point clear? Understanding the logic also. Think logically, guys. How is a subsidiary created? Because the holding company is controlling more than 50% of my voting power. Yes or no? Now, if I only go ahead and hold the company, hold the holding company also, then how is it operating? It's like a cycle. Not sure how many of you can make sense out of it. Am I audible to everyone?
Yes, sir.
All right. I repeat. Holding company is created when it is controlling the voting power of subsidiary. Do you power of the voting power of the subsidiary? Each one of you agree with this? Yes or no?
Yes, sir.
Now, imagine a situation where subsidiary is controlling the holding power. If subsidiary is controlling the voting power, then it is as good as me controlling myself. Wow. Why? How is it me controlling myself? Didn't make sense. I repeat. You'll have to pay attention. Huh? Listen to me very carefully. If holding company is controlling more than 1/2 of the voting power of subsidiary, and subsidiary is controlling the voting power of holding company, indirectly I'm controlling myself. Indirectly, the subsidiary controlling itself. Then where is the voting power? Where is the holding subsidiary relationship? Everything goes for a toss. Do you agree? Therefore, law says, don't come up with this nonsense. This is not allowed. Section 19 says, subsidiary cannot hold shares in holding company. Clear, everyone? So far, everyone understood? Inchara, I repeat. My parent can control me. I cannot control my parents. Understood? All right. In this situation, the holding company can have a voting power in my company, but I cannot have voting power in the company, in the parent company. This is exactly what section 19 is all about. Subsidiary cannot hold shares in the holding company. Clear, everyone? Crystal clear with the concept?
Yes,
Everybody understood the concept? Yes? Anyone wants me to repeat this? Everyone understood a word? All right. I'll give you 30 seconds. Think of few exceptions where it may be allowed. Old batch students, I want all the three answers from you. New batch students, think. Now, old batch students will stop coming to the session. Anyway, this guy is targeting specifically. No, I'm not. Please don't take me wrong. I'm just pulling your leg. Peacefully think. There are three exceptions to it. Think what could be the three exceptions where the child can control the parent. Right, wrong, don't bother. Give your answer. Even if it is nonsense, it's okay. We learn together. Who cares? Raise your hand once you're ready. This is a very interesting piece of law. What is the question? The question is, there could be three exceptions. I'm telling you also, there are three exceptions wherein the subsidiary can control the holding company, or rather can hold shares in the holding company.
So what if the people who are in power in the subsidiary company already have shares in the holding company?
Then that subsidiary is not controlling, right? It is the people in the subsidiary who are controlling. Pallavi, it is not the subsidiary holding shares in the holding company. Here, the people are common between both the companies, so they can go ahead and hold. It is as good as, let's suppose, Dhirubhai Ambani is holding the shares of Reliance Petrochemical. Dhirubhai Ambani is also holding, Mukesh Ambani is also holding the shares of Jio. Are you with me? All right. So Reliance Petrochemical might be the parent company. Jio might be the subsidiary. Am I holding shares in both? Answer is yes. But is Jio holding shares in Reliance Petrochemical? No. I am talking about a situation where Jio is holding the shares in the Reliance Petrochemical. Good thought. Start thinking. Anyone? Anyone? Not a wild guess. Right, wrong, don't bother. Make mistakes. We'll learn together. Try to karo.
sir, if the holding company is in the verge of bankruptcy,
If the holding company is in the verge of bankruptcy, can the subsidiary hold shares in the holding company? Bankruptcy is your own state, all right? The company state. That subsidiary is not going to go ahead and do something new for you. That may not be the case, all right? Think. Anything else? Brain is a muscle. It needs to be given an exercise every day of thinking, or else it'll die. Yeah? It's called as brain dead.
So the person who has the shares, the person in power who has the share in subsidiary company, what if they transfer their shares to the subsidiary company?
Brilliant. That is one of the examples. Anything else? Brilliant. That is one of the examples, one of the cases. Anything else? Attempt. Right, wrong, who cares? Pallavi, that is one of the examples. Anything else? Can we start now? Everybody understood the question at least, right?
Yes,
Anyone
sir.
who didn't understand the question? Anyone wants me to explain the question? I repeat, there are so many people who can't stand up for themselves. God knows. I repeat. The question is, can subsidiary hold shares in the holding company? Tilak, I'm very clear. No. Subsidiary cannot hold shares in the holding company, sir. There's no confusion at all. Second point which I mentioned, there are 3 exceptions in where the subsidiary can hold shares in the holding company. 3 exceptions. What are those? Let us learn together. Section 19 is giving an answer to it. Is the screen visible to everyone? Yes? No?
Yes, sir.
Yes,
Yes.
sir.
Yes, sir.
Yes. Can subsidiary hold shares in the holding company? The first point is 100%. No, subsidiary cannot hold shares in the holding company. Then we went on to, is the screen clear to everyone? Yes.
Yes, sir.
Yes, sir.
Yes, sir.
Second thing that you have to understand, where the subsidiary can go ahead and hold the shares of the holding company, there are 3 exceptions, which we are going to talk about one by one. Look at it very carefully. Huh? I hope the screen is visible to everyone. 3 exceptions. Subsidiary cannot hold shares. However, and holding company cannot transfer or allot shares to the subsidiary. There are 3 exceptions in which it can be done. First one, where subsidiary holds shares as legal representatives of a deceased member. Didn't understand? Listen to me. Let's suppose there is X Limited. There is a subsidiary called Y Limited. Y Limited has a member called Mr. Dhirubhai Ambani. Everyone with me? All right. Everybody knows Dhirubhai Ambani. Now, for whatever unfortunate reason, Mr. Dhirubhai Ambani passed away. X was the legal representative. All right, it was the representative of Dhirubhai Ambani. Dhirubhai Ambani had given a will. Whatever my assets are there, that will become the assets of Y Limited, Y Private Limited, tomorrow if anything happens to me. Now, in this case, let's suppose for unfortunate reason, Mr. Dhirubhai Ambani, Shrikar, got up. In this case, Y will become the shareholder because of the will. Do you understand? Dhirubhai Ambani had given a will. He had prepared, if anything happens to me, the shares will go to the company. And something happened to Mr. So therefore, the shares went to the company because the company was the legal representative. In this case, automatically, Y will hold the shares of X. Did you guys understand? Everyone? All right. I repeat, sit straight. X is the holding company of Y. No confusion at all. Mr. Dhirubhai Ambani is the shareholder, is the member of Y. Mr. Dhirubhai Ambani had prepared a will. You understand what is a will? All right. Finally, whatever the assets of the person who is dying will go to that person in simple terms. All right. So that person passed away. Now, when the moment Dhirubhai Ambani passed away, to whom will the assets go? To the company. But the company is a subsidiary of holding company, right? And the shares are also of the holding company. Dhirubhai Ambani has the shares of X. Dhirubhai Ambani has the shares of X. That's what will go to Y tomorrow if anything happens to Mr. Dhirubhai Ambani. Now, what is the situation? Subsidiary holding shares in the holding company. First point clear? Everyone understood the first example? Crystal clear with the first example? Second example now. Second exception. Subsidiary is holding shares as a trustee. Now, what is this, sir? Let's suppose. Listen to me very carefully once again. X has a subsidiary called Y. Listen to me very carefully. X has a subsidiary called Y. Your father is a shareholder of Y. Everyone with me? All right. Your father is a shareholder of X and Y both. Your father is a shareholder of X and Y both. Simple. No confusion at all. Now your father says, I have the shares of X and Y both, and my little one, you guys, are still minors or are still not mature enough. So it says, why you hold the shares of my child, all right, as a trustee. What is the meaning of the word trustee? The moment my child becomes major, that is, let's suppose 18 plus, you give the shares to this child. Until then, why will hold the shares as a trustee? Are you understanding? I repeat, everyone. X is having a subsidiary called Y. Your dad has the shares of X. Now, in this case, the shares are of daddy, and in this case, he wants to give it to you. But looking at your energetic faces and innocent faces, it seems like you are a minor. So you cannot hold shares as of now, at least. So what I will do, I will go ahead, or rather your father will go ahead and make Y as the trustee of those shares. Once you turn major, you will get these shares. Until then, Y is going to hold the shares of which company? X. Trustee. Clear, everyone? Understood the point? All right. Sir, then the first and the second point are one and the same? No. First and the second point are not one and the same. First point is where the law is asking about legal representative. The second one is trustee. These are not one and the same. Everyone understanding? There with me? The third one is where I was holding the shares of the holding company even before becoming its own subsidiary. This is exactly what our friend said. All right. Sit straight, everyone. What are we talking about? On 1st April 2026, everyone with me? X purchased 70% of Y. Holding subsidiary relationship? Yes. But as on 31st March 2026, Y was already a shareholder of X to the extent of say 5%. I had 5% investment in X. Now in this situation, I became the subsidiary later on. I became the subsidiary on 1st April, but I was already holding the shares of X. Are you understanding? Got the point? All right. So in this situation, I have become the subsidiary later on. I was already holding the shares of X. So therefore, this is covered under the third bucket where subsidiary purchased the shares even before becoming a subsidiary company. These are the three exceptions where a subsidiary can hold shares of the holding company. Now, question running in your mind, sir, if it is a subsidiary, then in the meeting, will the subsidiary also get a voting right? Law says control. Subsidiary, even if it is holding shares, because of these three exceptions, will not get voting rights in the holding company's meetings. That means you still cannot do any voting purposes. For voting purposes, that subsidiary does not exist at all. It will not get any voting right. Making sense? Now, everyone, the principle remains the same. Child cannot control the parent. How do you control companies? By voting power. I anyway don't have the voting power itself. So there is no question of anything on voting as well or controlling. Clear? Everyone understood the concept? Yes. So this is section 19. Sir, how do we remember it for examination? RTB. What is it? RTB. Representative, trustee. Before becoming the subsidiary itself, I was holding the shares. Clear, everyone? Crystal clear with section 19. Anyone wants me to repeat? Anyone wants me to repeat? I repeat. Guys, please be honest to yourself. You're sitting here not to impress anyone. We are here for an objective, with an objective. So let's be very clear. If I didn't understand, I didn't understand. He might have to repeat it. I'll repeat. There's nothing wrong in it. The concept that we are learning, Santosh, is section 19. Can you decide your father's career? Can you control your father? Answer is no. Section 19 categorically says a subsidiary company cannot hold shares in the holding company. Spurti? However, there are three exceptions in which the subsidiary can continue holding the shares in the holding company. What are those three exceptions? The first one is wherein Legal representative. If the subsidiary is a legal representative of the holding company, it can continue holding shares. Second one, wherein the subsidiary is holding shares as a trustee. Third one, where the subsidiary became or was holding a shares even before becoming a subsidiary. In all these three cases, subsidiary can control the shares or can hold the shares of the holding company. But wait, Chandana, they will still not get voting power. Crystal clear with the concept? Everyone? Everyone?
Yes, sir.
Yes, sir.
Brilliant. Let's go ahead with the next topic. Please stay focused. 100% important topics being discussed. Be there in the session. Is the screen visible to everyone?
Yes, sir.
Yes, sir.
Yes. Now let's take a simple example. Let's suppose each one of you have a girlfriend or a boyfriend, as the case may be. Happy? Sunday morning can't be as exciting as this then. No. What is wrong with... Something is wrong with you guys, or what? Who wouldn't want a girlfriend or a boy? I am telling you have a girlfriend or a boyfriend. Now you don't have those of you saying, no, I don't have. I am telling you have. All right. I'm not asking if you have. I'm very clear about the point which I'm making. All right. Now look at the smile on your face. Suddenly law sounds like love. Sit straight, everyone. How will you send notices? How will you go ahead and send letters? The so-called love letters. How will you send it to your partners? Go ahead. Be eventful. Be a little better than what I can expect from you guys. How will you send? Pigeons? Go ahead, answer, guys. You want to send a letter to your loved one. How would you do it? Is the crowd shy? You don't have to be shy. If the crowd is shameless, then it's fun. All right, go ahead. How would you send a letter to your loved one? The problem with this batch is the guys are also so quiet. Shy is coming. Answer, guys. I will have to connect it with the section. None of my questions are going to be independent. They will be all connected with the sections. Go ahead, answer. How will you send it? If I don't get an answer to it, I am skipping this section. Complete section itself. You read it on your own. How will you send the love letter to your loved one?
Dunzo.
Dunzo. Who dunzos love letters? All right. Sounds too exciting for life, but yes. How will you, for those of you who don't know Dunzo, you are living in a stone age. I can't really help. All right. For those of you who understand Dunzo, it's basically through another person I'm sending it. It's risky, huh? For those of you said, for somebody who said Dunzo, though sounds interesting, but risky. Next, anything else? Why is it risky? Your love letter falls in their father's hand. Both the loved one and the letter will be treated as a waste piece of paper in the bin. Anything else? What exciting answers can I get? Let's see.
Text a WhatsApp message.
Text or WhatsApp message. Unfortunately, I still remember I never had a phone until I was in second year of BCom, and I didn't have WhatsApp until I cleared CA. So both were not possible. Anything else?
Registered post.
Registered post. Interesting. All right. Now, those of you thinking, sir, who will send registered post? I will send registered post in that case. Now, what is your problem? Tilak was just about to say, what nonsense? Why will I send RPAD and all for this? As if I'm sending it to ICI. Anything else?
Giving card in person.
Giving card in person. This is much better and safer, all right, than doing everything else. What if it goes wrong? All the options that you've said, it could go wrong also, huh? What if instead of the recipient being your loved one, is not the recipient, but her immediate father is the recipient now, or his immediate father is the recipient now. Service of notice and service of document goes for a toss. Section 20 talks about this. Let's get started now. 100% focus. This is critical because if the notice is not served right, the entire meeting, the entire proceeding can be invalidated. Everyone with me? All right. Section 20 talks about a situation of how to serve notice or how to serve documents. When you're serving document, a document may be served. First thing that we are talking about, if you want to send it to the company, I'm not talking about company sending it to you. I'm talking about you sending it to the company for whatever notice you want to give, whatever communication you want to give to the company. When you are sending it to the company, how do you do it? The company, a document may be served on the company or an officer by sending it to the company or the officer at the registered office. That means you have to send it at the right address. If it goes to the wrong address, it is not a valid notice at well. I will give you an example why this is critical. Hold on. How do you send it? I can send it through registered post, a speed post, a courier. I can personally go and keep it and leave it at the registered office. I can send an email or any other mode. How can you guys not give email as an answer? I don't understand. All right. People are giving me RPAD as an option. You guys come from a generational history or what? You guys are giving me RPAD instead of email being the safest one. You guys are giving me an example of giving registered post. Wow. All right. Who is old, you or me? I am not sure. I'm not for sure. The last one. However, where securities are held with the depository, the record of the beneficial ownership may be served by such depository on the company by means of an electronic mode or any other mode. So what are we talking about? Let's suppose you are a shareholder of the company. Listen to me very carefully. Yeah? Very important topic. You are a shareholder of the company. When you're sending, let's suppose I want to tell the company, look, when you're giving dividend, please don't give it to my Axis Bank account, give it to my State Bank of India account, SBI account. Simple, everyone. This is an instruction which I'm giving it to the company. That means it has to go rightly to the right person at the right spot. If it goes in wrong hands, if it does not reach the office, then I might not get the money at all. Or it might not even serve the purpose. So therefore, section says, whenever you're serving any document on the company, you please ensure that it goes to the registered office. How should I send the notice? How should I inform the company? You can send it through a registered post, a speed post, a courier service. You can personally go ahead and give it to the company at the registered office, or you can send through an electronic or any other mode. Clear, everyone? When you want to inform something to the company. Now, the second thing is when the company wants to inform to the members. How will it do it? If the company wants to inform it to the members, they can do it through a post, registered post, speed post, courier, delivering at their office. All right. At your office, the company will send it, or it can be by electronic mode or any other mode. Crystal clear, everyone? Understood? Ready for a question now? Yes. Now let's suppose I have told the company very clearly, I don't want emails. I want it only physical copy through a registered post at my address. Listen to me very carefully. Yeah? I have told the company, whenever you're sending notices to me, you are the company. Let's suppose I have told you guys clearly, whenever you are sending notices to me, it has to be at the registered post. It has to be at my address, and it has to ensure that whatever communication is coming only in this means, it should not be in any other way. You have sent an email. You have not sent it through registered post. Can I say I was not given the notice itself? Did you understand the question? Everyone understood the question? All right. I have asked you to send it through a hard copy at the registered post while you have sent it through email. Can I say I was not given the notice itself? What do you think? Everyone understood the question?
Yes, sir.
Answer. Answer. Right, wrong, don't bother. Give your answers. You can have only two views, yes or no. Now, in this also, if you have confusion, God can save.
Yes, sir.
Can I say that I was not given the notice? Is it okay? Think. And what will happen if I don't get the notice? What if I go by Shreyas and Shreyas says, sir, yes, this will be considered as you were not given a notice. Now, in this case, what will happen if I am not giving the notice? Whatever decision you have taken in such meetings where I was not given the notice can be invalid. I can get that entire meeting scrapped. Are you understanding the power of the shareholder? All right. Now, if I have not given the right notice, then I can get the entire meeting scrapped. Now, coming back to the question, sir, in this case, you were not given through the registered post, but you were sent an email. Can the entire meeting be invalidated? Answer is yes. 100%. That's exactly why I've asked you. I have told you, you please give it to me in the registered post itself. Who asked you to send an email? No, sir, we are sending it to everyone, so we'll send it to you also. I don't care you doing it with everyone. I have given you an instruction, so you have to follow it. No, I will not follow is your answer. No problem. Whatever, if you've done a discussion without giving a notice to members, that entire meeting can be invalidated. Now, this happened with Vijay Mallya. This happened with Kingfisher. Kingfisher had decided, all right, initially, the first time they had decided to diversify their business in airlines. Everyone with me? All right. Eventually, they got into airlines. That's a separate story. So when one of the members had clearly mentioned, I want all the notices to be sent through registered post. Kingfisher Airlines had gone ahead and sent the notice through email to everyone. Now, the problem is, I had never asked through email. I was very clear that I wanted a registered post hard copy at my house. I didn't get it. The meeting happened. They decided that we will start a business called Kingfisher Airlines. But I didn't get the kind of notice that I was looking for. I filed a case against the company saying that this entire meeting has to be invalidated. Entire meeting was invalidated. Now, do you connect why I asked you how to send letters to your loved ones and all of this? One small mistake, section 20 gets triggered. Section 20 clearly says if the notice is not given right, the meetings are invalid. Understood the concept, everyone? Got the point? All right. So now, however, if a member requests for a delivery of any document through a particular mode on screen, everyone, for which he shall pay such fees as may be determined, the company in its annual general meeting. In this case, the company has to ensure that the mode which has been given has to be given in the same mode itself, no other mode. All right. Now, somebody said, sir, Dunzo can be considered as an example. Where will Dunzo sit? In which category will Dunzo sit? Can it sit in courier? Let's read the word. Courier means any person, a person or agency which delivers the documents and provides proof of its delivery. Now, I don't know if Dunzo can provide a proof of delivery. How will Dunzo prove a delivery? I can also say it does, because on the application, it still shows delivered. All right. And it gets delivered only with the OTP on the other side. I'm not sure how many of you know this. The other person has to give the OTP, only then the Dunzo's delivery gets over. Everyone with me? All right. So in this case, I can still prove that I have a proof of delivery, but questionable. Questionable. Am I clear, everyone? Understanding? So this is the meaning of the word service. Quickly read the rules. What we are discussing is an important topic. They've asked several times question on servicing of document. This is probably one or last two sections left. Read quick. I can, by the way, I can also send, did you look at it? I can also send through an electronic mode. What do you mean by electronic mode?
Email.
Only email? Anything else can be covered here? WhatsApp message? The company has sent WhatsApp message to you.
It is informal, no, sir.
I don't know. You'll have to tell me. What do you think? It is informal? The company has sent, let's suppose, a simple thing. They posted on Instagram that we have a meeting. And you guys have seen, it's there in the scene notification as well. Is that electronic mode?
No, sir.
No, sir.
Now you will come up with all such fancy ideas. That's why the rules are already prescribed. The rule 35 clearly says, what do you mean by electronic mode? I will only tell. You don't come up with 1,000 alternatives. You will put a story on Instagram and tell that you saw, I saw, that you saw. All right. So it is a valid delivery. Guys, you think all this doesn't happen, but actually all these are the issues before the court. So to avoid all possible confusion, they've already come up with the rules on what do you mean by the electronic mode? Read, one of you, quick.
Section 20, Service of Documents. As per the Rule 35, Service of Documents of Companies Incorporation Rules 2014. The term electronic transmission means a communication that creates a record that is capable of retention, retrieval, recovery, and review, and which may thereafter be rendered into clearly legible, tangible form. It may be made by
Facts.
facsimilar, telecommunication, fax, or electronic mail, email, which the company or the officer has provided from time to time for sending communications. Posting of an electronic message board or network that the registrar or the member has designated for those communications, and which transmission shall be validly delivered upon the posting or other means of electronic communication in respect of which the company or the officer has put in place reasonable systems to verify that the sender is the person purporting to send the transmission. In case of delivery,
Sit straight. Hold. What are we talking about? Sir, in case if I want to send electronic transmission, what do you mean by electronic transmission? It can be sent over fax, it can be sent over email. Understanding, everyone? All right. So if something can be sent over fax or email is considered as electronic transmission. No, sir, I want to put it on Telegram. Telegram was used the highest at the point of COVID. Not sure how many of you are aware, because WhatsApp group had a restriction on the total number of members. Do you remember COVID period? All right. WhatsApp group had a restriction on the number of members. To avoid that, people started porting to Telegram, where there were thousands of members can be added at a single shot. Now, can I say I've sent it over Telegram? Is that okay? Law says I will leave it to you. Any other mode wherein I get a valid proof of delivery can be considered as electronic mode. I need a proof that it has got delivered. If I can prove it, it is a valid form of electronic transmission. Clear? In delivery by post, now very important, delivery by post, instead of electronic mode, I'm sending it through a courier. I'm sending it through a registered post. Today is the meeting. The registered post comes to you today itself. When will you plan? When will you go for the meeting? Is there a problem? Yes. So law answers this also. Very interesting answer. Such service will be deemed to be have effected. That means it's a valid delivery only if that notice is given at least 48 hours after the letter is posted, and in any other case at the time at which the letter has been delivered in the ordinary course of post. What is the meaning of this? I have sent it. You were not there at home. You were not there to collect. Now law says in that case, within 48 hours, if there is no reply from anyone, assume that they have received the notice, and now it is their problem to go ahead and check. Because I have lakhs of shareholders, I can't chase everyone. So in that case, within 48 hours, it is assumed that it has got delivered. This is in case of registered post. Clear, everyone? Understood? All right. This is in case of registered post. Probably one last section, section 21. Sit straight. Let's suppose it's your company. All right, let's take an example. Say, Chandana there. Chandana.
Sir.
All right. Let's suppose. Shant there in the session. Quick.
Yes, sir.
Respond. All right. Chandana and Shant, they are shareholders. They are companies. All right. Say Chandana Private Limited. Sit straight, everyone. Chandana Private Limited has two directors, Shant and Mehul. Simple. Now I have a confusion. When Chandana Private Limited, you have sold goods to Chandana Private Limited. You are supposed to receive the money. You've sold goods to Chandana Private Limited. You are supposed to receive the money. Yes or no? Now, the check is being given by Chandana Private Limited. But who will sign the check? Did you understand the question? Chandana Private Limited wants to make the payment to you. But somebody has to sign the check, right? Of Chandana Private Limited. Who will sign the check?
Sir, usually the key managerial or the common seal will be there.
Common seal. My company does not have common seal. Is it mandatory to have common seal?
No, sir.
My company does not have common seal. Now,
Key managerial people like the company secretary or the CEO, anyone like that.
interesting. Everybody understood the question at least, right? Section 21 answers this question. All right. It is talking about authentication of documents. What is this? In case if any document has to be signed, who is going to sign? How is it going to be signed? Look at it. Any document which has to be signed can be signed by KMP, key managerial personnel. All right. Or by any officer, employee of the company, if the board of directors have authorized that person. I'm not a KMP. Let's suppose I'm just a normal employee, but the board of directors have given me the authorization to go ahead and sign the documents. In that case, can I sign? Answer is yes. Sir, but you're not the KMP. It's okay. But the board of directors have given me the authorization. I will go ahead and sign it. No problem at all. Now the question running in your mind. Sir, who is the key managerial personnel? Section 2, clause 51 defines the KMP. Are you understanding? Everyone with me? All right. So who is a KMP? KMP means any person who is the CEO, MD, manager, CS, whole-time director, CFO, or any other person not more than one level below the directors. So one person immediately below the directors. Okay. 10, 20 levels below the director, not okay. So one person who is not more than one level below the directors, who has been authorized by the KMP, in that case, that person will also be covered within the definition of key managerial personnel. Did you understand? So who is a KMP? Asha? KMP is a person who is authorized by the company. It could be your CEO, CFO, managing director, whole-time director, any other person who is not one rank below the directors. In that case, even that person can be considered as a KMP. So these KMP can go ahead and sign the documents. Crystal clear? Everyone understood the point? All right. Now coming to any bill of exchange and all of those. If any check has to be signed, if any other document has to be signed, how do you sign those? All right. Now, in this case, check whether the company has common seal or yes or no. Triti, your answer. Now, if the company, is it mandatory to have a common seal? Maybe, maybe not. It's not mandatory to have a common seal. What is common seal, by the way? What is
A
common seal?
symbol that represents that it is a document of the company, official document of the company.
Brilliant. All right. It's more like a seal. Your college seal, do you remember? Similarly, there is a seal by the company as well, Pavna. In this case, if there is a situation where the company has a common seal, then that seal will be put on the document. All right. In writing, authorize any person as attorney to go ahead and sign the documents. It will be considered as signing those checks. I'm talking about an example where I want to sign a check. If my company has seal, law says, along with that seal, any other person who is authorized by the company to go ahead and sign will be signing the checks. I'm giving check as an example. It can be any other bill of exchange as well. Now, second situation, sir, my company does not have a common seal at all. Spurti. Now, in that case, what will I do, Prakriti? In that situation, either it can be signed by two directors or company secretary along with the director. Are you understanding? So in a situation where my company has to sign, then it can be signed by two directors, or it can be signed by one director and one company secretary. This is execution of bills of exchange. What is the meaning of the word execution? Who will sign the bills of exchange? Clear? Understood, everyone? Next point. Last section, section 8, which I'd started long back. All right, I've given you a quick reference, but now I'm going to quickly revise this as well. Sit straight, everyone. Those of you who are tired, those of you who are exhausted, keep sipping water. Life is easier to that extent. All right, let's get started now. Section 8. All right. Section 8 is a company which is formed for a particular purpose. I think I'd given an example also. Infosys Foundation. Sit straight. Those of you who've come across Nirmala Swachh toilets, have you come across? All right. Who is running those toilets, or who are the one who has built those toilets? Do you know in public places there are washrooms? Now, who have built those washrooms? At times, not all, at times, those are built in the name of Nirmala Swachh toilets. You should be a little keen observant of what is happening around you. Other than just seeing Instagram reels, life will become a little better. I'm surprised so many of you might have used public transport so often, but still you don't know about Nirmala Swachh toilets. It is one of the biggest foundation projects of Infosys Foundation. Are you understanding, everyone? All right. So Infosys Foundation is a Section 8 company. Do you know Reliance Foundation? Yes. If not Infosys Foundation, at least Reliance Foundation. Forget it. Do you know Marathon? TCS has 10K marathon, 5K marathon. Have you heard about that at least? Yes. If that also you don't know, I genuinely have no other examples to give. All right. TCS marathon, if you see, somebody is organizing it, right? Who is doing it? It's the TCS Foundation. Next time when you are seeing these, you should be keen enough to understand, sir, who is paying for all of this? It's not happening free of cost. If you realize somebody might be spending money for it, right? Who is paying for it? It's these foundations, Section 8 companies. Now, what are these Section 8 companies? Section 8 companies, on screen, everyone, are those companies which are formed for the charitable objects. Those companies are called Section 8 companies. Now, what is their objective? Their objective is to promote the social welfare. That is the objective of a Section 8 company. It's not everyone, few Section 8 companies. Now, where can they use profit? First thing, can they have profit motive? No, they don't have any profit motive. In Chara, they do not have profit motive. Second thing, on screen, keep your things aside. Close your books, focus on screen. Don't get distracted. The whole point is you'll have to pay attention to these topics. Section 8 companies will not generate, or rather are not with a profit motive. But sir, incidentally, I've earned profit. Possible? Example, TCS. Let's take an example. TCS has a TCS marathon. You have to pay 500 rupees if you want to join this. Everyone with me? But actual cost that they might have incurred might be significant. Now, so many people have joined. I thought only 1,000 people will join, but effectively 10,000 people have joined. Now, what will I do? I have earned profit there. My expenditure was not for 10,000. My expenditure was only for 1,000 people. But 10,000 people have joined, so I made profit there. Was profit my motive? No. But incidentally, I've generated profit. That is okay. No problem. Now, I will give dividend out of this profit. Is it okay?
No, sir.
Now, says
No,
control.
sir.
You've generated profit till there, it is fine. But you cannot declare your profits as dividend to your members. This is the first condition for a Section 8 company. Sleeping?
No, sir.
No,
No,
sir.
sir.
No, sir.
Then your question is, sir, for what purpose will I use this profit then? Where will I use this profit? Use it for your objective. Why were you created? Use it for that. This is on Section 8 companies. Understanding on the profits. Now, what type of company can you be? You are always a limited liability company. Why? Sir, you're here for charity. How can your liability be unlimited? Whoever is your member, will they sell their house and do charity? Will they sell their kidney and do charity? Will you do it if you are a member? The moment it comes to you, you are very clear. No, sir, we will not do it. That's the whole point. Nobody will do it. All right. So the liability is always limited. But very interesting. I said, Nagratna, I said Infosys Foundation, TCS Foundation. I never said TCS Foundation Private Limited. I never said Infosys Foundation Private Limited. Why? Because they are exempted from the usage of the word limited or private limited. Clear? These kind of Section 8 companies do not have to use the word limited or private limited. This is the first exemption of a Section 8 company. Bhavani, there. Next.
Yes,
Sir,
sir.
who will recognize, who will give me the status of a Section 8 company? I like the way you are smiling. All right. This in itself is a charity. So I am a Section 8 company. What nonsense. Who will give this status, sir? Who will give this entire recognition to me as a Section 8 company? Central government will give this status. Now, central government has better things to do, Tanushree. So what? Who has been given the power? The power has been given to the registrar of companies to grant this license of Section 8 companies. Clear, everyone? Understood so far? Next thing. Tomorrow, let's suppose I was formed for charity, but instead of charity, I'm doing business. Are you with me, everyone? Instead of charity, I'm doing business. Now, law says what you're doing is not right. Your objective is not charity anymore. In that case, what will happen, sir? Your license can get revoked. They will cancel your license. That means you're just like any other company. Now, what will happen, sir, if my license is covered, is cancelled? If your license is cancelled, you're just like any other ordinary company. Start using, first thing that you will do, shut up and start using the word limited and private limited in your name. Logical? Because I had given you an exemption of not using these words. Now you shut up and start using the word limited and private limited. That means liability is going to be there, limited liability. Connecting dots, everyone, making sense? This is the whole concept of Section 8 companies. With this, we come to an end of the first, or rather, I would say the second chapter called Incorporation of Companies. We've spent close to 4.5 hours only on this chapter. We've discussed in length and breadth. Now I'm going to discuss examination questions which have been picked up in the past from here. Ready, everyone? Yes?
Yes, sir.
Sit straight and listen to me. Let's try solving a couple of examination questions to see where we stand. Is the screen visible to everyone?
Yes, sir.
Yes, sir.
Yes, sir.
Read.
May 2024 RTP, Ram Private Limited is holding company of Lakshman Private Limited. As per the last profit and loss account for the year ending 31st March 2023 of Lakshman Private Limited, its turnover was 1.80 crore and paid up share capital was 80 lakh. The board of directors wants to avail the status of a small company. The company secretary of the company advised the directors that the company cannot be categorized as a small company. In the light of the above facts and in accordance with provisions of the Companies Act 2013, you are required to examine whether the contention of company secretary is correct, explaining the relevant provisions of the Act.
It's correct, no? What the board of directors are saying is correct. Why it cannot be a small company? It is having a paid up capital and turnover less than the limit which has been prescribed. What is the limit under Section 2 Clause 85? Section turnover 100 crores, paid up capital 10 crores. I am within the limit itself. What is the problem? Directors are right. Do you agree?
No, sir.
Why?
It is a holding company.
Which one? So Lakshman is not the holding company. They are asking about Lakshman.
Sir, the
Holding and subsidiary are the
subsidiary
exceptions.
Yes.
Understood? Everyone? Lakshman cannot become a small company because it's a subsidiary company. Section 2 Clause 85, if you remember, we had categorically learned small companies cannot include holding, subsidiary, Section 8 company, any company governed by a special act. All of these are covered, are kept outside the definition of the word small company. Clear? RTP question. I hope each one of you will be able to solve such questions. Clear? Next. By the way, which RTP was it? 2024 RTP, May attempt. Next.
November 2022 RTP, Mr. Aditya had incorporated a one-person company on 7/7/2021. Mr. Yash was named as a nominee in the memorandum of the said one-person company. Now, Mr. Aditya, considering the perpetual nature of the company form of business, desires to appoint ABC Private Limited as a nominee instead of Mr. Yash. Examine the reference to the Companies Act 2013 whether the proposal of Mr. Aditya to appoint ABC Private Limited as a nominee is valid.
It's fine, right? What is the problem in this?
No, sir.
Not a natural
sir.
person.
Only
Not a
natural person.
Only natural person, Indian citizen and resident in India has to become a member and
Whether or
nominee.
Whether
not
a resident
in
or
India.
Whether resident or not. Able to recall everyone? All
Yes,
right.
sir.
Residential status is whether or not a resident. Everyone comfortable? Can I continue? Yes.
Yes,
So in
sir.
this case, can the company become a nominee? Answer is no, only natural persons. Next.
May 2022 RTP, one of the matters contained in the articles of Dhiman Foundation, incorporated as a limited company under Section 8 of the Companies Act 2013, was altered by passing a special resolution in its general meeting and thereafter. Intimation for the same was given to Registrar of Companies. However, such alteration in the articles was opposed by Dhwaj and Co., a partnership firm, which is its members that their such alteration was not valid. Advise as per the provisions of the Companies Act 2013 whether the contention of Dhwaj and Co. was valid and whether it can be a member in such company.
I'll give you 30 seconds. Don't give me the answer. I'm sure you don't know. All right. Just give me the question. Just explain the question to me. Just explain the question to me. Explain the question. Divya there in the session. Mufida there in the session.
Yes, sir.
Insist you to keep your cameras on.
Yes.
Kiran there. Just explain the question. Anyone?
Sir,
If you
so
don't
the
understand, go ahead, Triti.
yes, sir. Sir, Dhiman Foundation is a Section 8 company which wanted to alter its AOA by passing a special resolution in the general meeting, and the intimation was given to the registrar of the companies. But this what do you say that? This changes in the articles was opposed by one of its members, which is the Vajenko, which was a partnership firm. So they're asking us if whether or not whether that
Opposition.
yes, opposition was valid, and whether that partnership firm can be a member of such a Section 8 company.
What do you think? Any answers? No answers.
Sir, a firm cannot become member in Section 8 company.
Brilliant. First point. All right. Whether a partnership firm can become a member in any company, forget about only Section 8 company. Can a partnership firm become a member in any company? Answer is no. Why? Why no?
Not a separate legal.
Not a separate
Brilliant.
legal
Sir,
entity.
partnership firms are not separate individuals. I don't recognize their existence at all. Sir, no, sir, my partnership firm should hold. I want my partnership firm to hold shares. Then what can they do? Hold it through your partners. The partner is going to hold it on behalf of the partnership firm in that case. Clear, everyone? This is the first thing. Second question that they have asked is whether such contention, opposition, which they have, all right, whether the contention of Dhwaj and Co. that you cannot alter is valid. Can the company go ahead and alter? What do you think? Read section 8 now. Anyone? The answer.
According to Section of the Companies Act 2013, a company registered under this section shall not alter the provisions of its memorandum of articles except with the previous approval of central government. The power has been delegated to Registrar of Companies. Also, a firm may be a member of the company registered.
Hold. Before we go to the firm, first point, everyone, those of you sleeping, wake up. Good morning.
Good morning, sir.
Brilliant. All right. Now wake up. Sit straight and listen to me. In a situation where a Section 8 company wants to alter its articles of association, law says, I don't want you to go ahead and do it without the approval of the central government. Why? Don't forget you're doing some charity. All right. And charity, I want to ensure it is with the approval of the central government. What will happen? I'll give you an example. They will take the license of a Section 8 company and then quietly start altering the articles of association, memorandum of association. They will change their objective, but still hold the license of a Section 8 company. People in India can do anything. All right. India is not for beginners. I'm very clear about it. Now, in this case, law says, I don't want you to alter your articles of association until and unless central government approval is given here. Did you guys understand the first thing? All right. So central government approval is mandatory for any alteration. First point is clear. Now, central government, do you think Mr. Modi is going to give the approval? Who will give the approval? They have better things to do. So they've delegated the work to Registrar of Companies. Clear, everyone? So far, understood the point? Yes. Now, the second question, whether a firm can become a member under this registered of a company under section. All right. There are two views. A few of them in your RTP, they mention that a firm can become a member of Section 8 company. But if you ask me, a firm cannot become a member of Section 8 companies or any company because it does not have a separate legal existence. Are you understanding? So to that extent, our answer is going to be conflicting with what is given in the RTP. I hope I'm clear. Everyone understanding? That's exactly why I picked up this question. One of the matters of articles of Demon Foundation was altered by passing the special resolution in the general meeting, and hence the intimation for the same was given to the ROC. As per the provision, it is necessary to take the first approval of ROC, which was not done here. And therefore, the contention of Dwaj company was valid and it cannot be allowed. So what is the problem here? The problem is they passed the special resolution and then informed the registrar. It's not that way. It's ulta. First take the approval of registrar and then pass the resolution. Sleepy?
No, sir.
Everyone understood the point? Yes,
Sir.
crystal clear. Second question, whether a partnership firm can become a member in Section 8 companies. Please note, first question, let us try to answer. Can a partnership firm become a member in a company itself? Answer is no, because it does not have separate legal existence. In RTP, they have specifically mentioned that it can become of Section 8 company at least. To that extent, there is a contradiction. All right, to that extent, there is a contradiction. What is the final answer then, sir? We will stick to what is there in the RTP. We will write the same point that here, in this case, a partnership firm can become a member of Section 8 company. However, a view can be taken that a partnership firm cannot become a member of any company as such. You give your comprehensive answer. You give your complete answer. Clear, everyone? Understood the point? All right. So this is about one of your main RTP questions. Next. Read next. Guys, comfortable? We are solving most of the questions during the classes itself. So pay attention. Read next.
Me
May
too.
2018 RTP, MNO, a 1% company, was incorporated during the year 2015-16 with an authorized capital of 45 lakh, 4.5 lakh shares of rupees 10 each. The capital was fully subscribed and paid up. Turnover of the company during 15-16 and 16-17 was 2 crores and 2.5 crores respectively. Promoter of the company seeks your advice in the following circumstances: whether MNO OPC can convert into any other kind of company during 17-18. Please advise with a reference to the relevant provision to the Companies Act 2013 in the below mentioned circumstances. If promoter increases the paid up capital of the company by 10 lakh during 17-18, if turnover of the company during 17-18 was 3 crores.
Sir, we didn't understand head and tail of this question. Sit straight. What is this question? They want to convert an OPC into any other kind of company. Sit straight, sit straight, sit straight. When the Companies Act 2013 was introduced for the first time, OPC, if it wants to convert itself into a public company or private company, there were conditions to be satisfied on the turnover and paid up capital. No such conditions are relevant now. They have amended the law. They say if you want to convert, convert. I have no problem at all. Sir, should I check the previous year turnover? Should I check the previous year's capital? Nothing doing. You can peacefully go ahead and convert yourself. So this question to that extent becomes irrelevant because this question earlier, the law had requirements of satisfying turnover and paid up capital requirements. Now the law does not have any such requirement. The law just says if you want to convert, you can go ahead and convert. And conversion process, we have already seen OPC to public company and private company. I've discussed it with you guys. Clear, everyone? Understood? Yes or no?
Yes, sir.
Yes, yes.
You've discussed section 18, conversion of a company. All right, different types of conversion, we have looked at it. So in this case, law is very clear. In case if you want to convert into a private company, we have no problem. You don't have to check the turnover and requirements of paid up capital. So this question becomes irrelevant to that extent. Read next.
November 2019 RTP, Red Limited was incorporated on 1st April 2014, is facing severe effects of depression of the economy. Owing to its bad financial status, most of the members have started withdrawing their holding from the company. The company had 250 members on 10th January 2019. By 15th January 2019, 244 members had withdrawn their holding. No new member has invested in the company after 15th February till date. Now, Mr. A, an existing member, has approached you to advise him regarding his liabilities in such a situation.
I'll give you 30 seconds. Raise your hands with your answers. Brilliant question this is. Let's see how many of you can crack it. Attempt. Those of you who are sitting with the whole thought process, why should I try and all that nonsense, you'll have it in examination. You'll have a lot of problem in examination. Go ahead, attempt. Raise your hands once you're ready with your answers. In this batch, only girls answer. Finally, I saw at least somebody raising their hands. I'm happy to see that. Good. I can, Mufida, you had raised your hand. Manasa, Vatsal, Tanushree, Kirtana. Pavna. Good. Answer, quick.
Red Limited is a public company.
It is.
Company had 250 members. Now it is reduced. The 244 members are withdrawn their holding. I think the minimum membership reduced.
Brilliant. All right. Very good. Minimum number is not satisfied. What is the problem then? What is the minimum number right now they have? 6. All right. Not the minimum number. What is the number of members as such they have? 6. What is the problem?
Section 3A.
Brilliant. All right. Manasa, Vatsal, Tanushree, Kirtana. Anything else you want to add?
They are liable for.
They're liable for the debts of the company. All right. Anything else? Vatsal, Tanushree?
Sir, they'll be having 6 months time period. Within that, they should comply with the number of members. If they will not, they'll be personally liable for all the liabilities.
Section 3A.
Excluding
All
those
right.
6
Which
months.
support? Within 6 months. Perfect. Within 6 months. Now, those of you are counting stars, what is this question itself? Sir, there were 250 members. Now, those 250 members have been reduced. 244 members have left the company. So effectively now, how many do I have? 6 members. Which company is it? It is a public company. As per section 3 subsection 1, I must have minimum number of members that in a public company should be 7 or more. In this case, I have 6. So what should I do? Section 3A comes into picture. Section 3A says that you cannot have less than the minimum requirement. No, sir, I have a 6, less than the minimum requirement. No, what should I do? 6 months is what you have. Those members who are continuing should reinstate the number to 7 or more. Sir, I was not able to do it. No problem. After 6 months, whatever debts you attract will be the personal obligation of the members who are continuing. Clear, everyone? Understood the question? I hope you guys are enjoying. Important, brilliant questions. These are all. And these are all RTP questions that I've picked up. Next.
May 2020 RTP, Yadav Dairy Products Private Limited has registered its articles along with memorandum at the time of registration of a company in December 2014. Now, directors of the company are of the view that provisions of articles regarding forfeiture of shares should not be changed except by a resolution of 90% majority. While as per Section 14 of Companies Act 2013, articles may be changed by passing a special resolution only. Hence, one of the directors is of the view that they cannot make a provision against the Companies Act 2013. You are required to advise the company on this matter.
I'll give you 30 seconds. Raise your hand. Somebody who's already got a chance, don't raise your hands. The problem is others are not even attempting. So I will eventually give it to those who are attempting. Guys, you will have to fight. It's a very competitive world that you're looking at. I am very surprised that there's no competitiveness at all in this batch. People are not even attempting. Right, wrong, who cares? We're solving examination question. Your answers, I'm hearing it to you personally. What else do you want? After telling all this also, people are in their own life. Good, continue. Only 3 hands? Perfect. Let us have, I'll call out the names. If you have anything to add, you can raise. Triti, Shreyas, Tanvita, Manasa, Tanushree, Tilak, Kirtana, Spurti, Mofida.
Sir, the 90% majority can be taken as against the special resolution, which is only 75% of the majority because of the entrenchment of articles.
That is the answer. This question is revolving around entrenchment of articles of association. All right. You'll have to be quick if you want to be the first one to answer. If you had the same answer, you'll have to be quick. As simple as that. All right. Now, coming back to the point. Sir, entrenchment of articles of association is required, but there is something which is not complete in this question. 90% is making the law stricter for yourself. When your law really wants only special resolution, but you're saying no, instead of 75%, we'll pass 90%. But for this, how many members of your company should agree for entrenching it? How many?
Unanimous.
Unanimous.
Why unanimous?
Private
Limited.
Open your eyes, ears, and look at the question. It is a private limited company. So if you want to entrench your articles, Section 5 says you will have to pass a unanimous resolution of all your members agreeing to make the law stricter for yourself. Only after a unanimous resolution, you will be able to pass this. Clear? Everyone understood? Yes. Next.
Yes.
In your study material, all right, page number 43 has a couple of scenarios. I want to ensure that you guys go through those scenarios. It's an important topic which each one of you have to read. I think this is about the entire chapter. Have you guys got your CAPS material? Yes,
sir.
no? Already received your CAPS material?
No, sir.
Yes, no, what? As in, will
Collecting,
it be
sir. Still collecting.
collecting as in
Collected.
you have to go personally and collect it, or will they courier it to you guys?
courier, sir.
Sir, both are there.
Both options.
Both
Both are
options
options
are
there.
there.
All right.
Yes, sir.
I think online classes are much better in that case because you don't have to move around. I still remember I had to travel. So when I used to have classes, I used to travel at least 12, 13 kilometers and at least leave my house 1.5 hours prior to the session. All right. I used to commute by buses. So it used to be very clear 1 hour at least I have to keep in my mind and then reach the classes. It's absolute convenience. Of course, physical has its own touch, but you can't discount that online classes are equally important and equally doing well. Now, if you ask me, it's so comfortable that you don't have to plan 1 hour prior and leave. Most of you wake up 5 minutes before the class. That also somebody might have kicked you out of your bed and that's when you would have woken up. All right. I hope that should not be the case. Each one of you are going to become chartered accountants. The economy of the country will pass through your hands. And that vigor has to come in from you. It should not be from outsiders. Now, I will open your CAPS material. This time's CAPS material, I have first thing. All right. I myself made your CAPS material. So those of you thinking, sir, CAPS material is enough. Answer is no, it is not enough. I will answer a couple of questions which are there in your mind, sir, how to read, what to read, all of that. Just hold on. Before that, let me know if the screen is visible. I want to show something which is additionally included in this time's CAPS material. Is the screen visible to everyone?
Yes,
Yes,
sir.
sir.
Yes, sir.
Yes, sir.
In your CAPS material, so this entire chapter is of 24 pages. If you see in your CAPS material, there are something called important questions. All right. Is the screen visible to everyone?
Yes, sir.
There is something called practical questions. And there is also something called as multiple choice questions. Now, this brings us to the most important thing, case law questions, previous year questions, model paper questions. Everyone with me? All right. And thereafter, you have few definitions which they have asked in examination, important sections that they have focused in the examination. So if you see what we have done in the CAPS material this time, it was there earlier, but this time I've made it a little comprehensive. I have gone ahead, picked up all or rather most of the important questions in the previous examinations that they've asked, MCQs that they've asked, usually across topics, across papers, where all they have asked definitions. What kind of definitions have they asked? All of that is consolidated in your last few pages of the CAPS material. Every chapter I've done this. Consciously, every chapter has this. What is your responsibility now? Sit straight, everyone. Each one of you are going to study. The first thing is going to be your study material. Listen to me very carefully. Sir, how to prepare for law? I'm answering that question now. First thing that you're going to do is study material. Sir, but the CAPS material is there? No, sir, enough? No. No, it is not enough. I have prepared the CAPS material. I know how I've prepared. I have not copy pasted your study material as is. If that was the case, I would have just given you the study material once again. I have not done that. Sir, then what is CAPS material? CAPS material is a quick glimpse of the entire chapter which you can use one day before your examination. Because in one day before examination, you will not have time to go read your study material. Are you understanding? Everyone with me? All right. So what are you going to do? You will finish your study material first. Then you will read your CAPS material and solve all these questions which are lined up. If you have an answer to each of these questions, more or less, you've covered 80-90% of your syllabus. Are you understanding? Everyone with me? All right. So please ensure each one of you finish the study material, finish the CAPS material, solve all these questions before we pick up the next sessions. Listen to me very carefully. Next class, not the next class, or the class after my next class. So my next class is going to be tomorrow. I will not bother you tomorrow. But the class after that, whenever it is, you will be writing a test on incorporation and formation. I will just stop here and give you the importance of these regular tests. Earlier, I never used to take so many tests and all of that because the schedule is so hectic and we have a lot to cover. After starting these tests, 90% of the students come back and tell, sir, law has become easier for us because we've been holding tests regularly. We've been covering the syllabus as and when we have finished during the classes itself. Please note, most of you would be writing your examination, if I'm not wrong, in September. That's the plan. All right. When are you guys writing your examination? Most of you?
January, sir.
January. All right. January 27 is when most of you will be writing. All right. Please note, you will effectively have very limited period of time later on. I have just finished one chapter now. You will see slowly the quantum of work involved in each and every chapter. Please don't wait for your 2-3 months of holiday to read law. If you're doing that, I am telling you, I've seen students getting 75 in accounts and 35 in law. Law is a theory subject which requires revisions every now and then. I'm not mad to spend 15 minutes every day in the morning before I start today's topic. I start with the revision. There is a reason, because more and more and more and more and more on vision of those topics, you will have a better memory. Am I clear, everyone? Guys, do something for yourself, not for me. Next class, next but one class, whenever I take the session, there will 100% be a test. My tests are important for me. Whether it is for you or not, I don't care. But for me, it is equally important. Now, you can't tell me, sir, I was not having sufficient time, because I'm announcing prior. I'm giving you at least 2 days of time. Tomorrow's test, tomorrow's class, I'm not going to have the test. But after that, whenever my session is there, you have a test. Where will you study from? In corporation, come prepared for one of the toughest papers. You will see what CA exams are in the questions when I start dictating. Sir, from where will you pick questions? Don't sit and gauge. I will not refer to any of the materials. I will frame my own questions while I'm dictating to you guys. So prepare accordingly. It's very, very important. For me, I don't care about what you think. It's important for me. Am I clear, everyone? Now, please ensure you write as much as possible for the questions in law. I was having a quick feedback session from students who have got rank and whoever cleared the last intermediate examination. Their quick pointer is, sir, law paper, we think we've understood. But once we start writing the answers, we are not able to write even 10% of the suggested answers. Are you hearing me? Why? Because keywords are important. You are not able to produce those. Important section numbers are there. You're not able to produce those. And if you're not able to write those, you will not get marks. Am I clear? Yes, I have seen students getting 75 in accounts, but still flunking the entire attempt, guys. They had to write that entire attempt once again because of getting 35 in law. Law is one paper which can make or break your entire group one. I hope I'm clear, everyone understanding the point. Yes. So please ensure that you spend enough time in writing answers to each of those questions which I've listed below the caps material. How will I write answers, sir? Should I sit and write the entire answer as I would have written in the examination? No. At least after your caps material, after that chapter, staple a few empty pages or have another 200 pages separate book. In that, you start writing keywords for each of the answers after you finish reading your study material and caps material. That in itself is a good test for yourself. Write keywords. These are the keywords which should be there in my answer. I'm not asking you to write all the answers. I'm not asking you to write the entire answer of each question. At least you should know what are the keywords which I'm going to write if this is a question. Do it for yourself. Once you have an answer for all those questions which are there behind your caps material, you will have a fair confidence on the entire topic. Clear, everyone? Making sense, everyone? Even
Yes,
after
sir.
telling all this, I know 30% of you, 40% of you will not write. I know those students will come back and attend the batch for the next attempt again. Bitter reality, do it for yourself, not for me. I am not going to sit and check. I'm also telling you, I'm not going to check if you've written or not. Do it for yourself. All right. If you want to clear in the immediate attempt, do it. No, sir, I have a lot of time. I'm free that way. I can write 2-3 attempts. I'll leave it to you. I have no problem. Sit straight now. Let's go ahead with the next chapter. Is the screen visible to everyone?
No, sir.
No?
No, sir.
The next chapter is called begging and borrowing. Everyone there? Sir, what nonsense is begging and borrowing? Prospectus and allotment of securities. One of the most interesting chapters because you will be seeing all this happening around you. Did you recently come across IPOs? What are IPOs?
Initial public
Initial
offer.
public.
What is the initial public offer?
Subscription clause.
Subscription clause. IPO is subscription clause? No. What is this
Company
IPO?
raises money.
Public.
I'm sorry?
Where the
First
company
share
raises
holder.
money through issue of shares.
Company raises money from public, all right, through issue of shares. Anything else?
For the
It's
first
the
time.
first time it goes to the public.
First
With the
time when it
offer.
goes to the public is called an IPO. Anything else?
Converts private limited into public limited.
Conversion? Maybe not. Maybe not. Maybe not. Ready? Everyone? Let's quickly take an example. How many of you know physics wala? How many of you know physics? It's a listed company. Huh? You can't act as if you have no idea. Guys, Those of you thinking I will read study material and clear examination, you will clear examination, but you will not become a successful chartered accountant unless you know what is happening around you. I am very clear. By now, you should have realized this person is not going to talk about only content in your study material. No, I'm not going to do that. Those of you who really want me to stick to your study material word by word, I am not one of those. Please note, physics wala. You know the story of them? What happened? Anyone? Everyone? You know this company called Physics Wala at least?
Yes, sir.
Yes, sir.
Yes, sir.
Yes? No? You know what was
Yes,
the story? For those of you who don't know, there is a Netflix series. Go at least, not that at least you'll do. All right. Till what is the name of the Netflix series? It's called Hello Bacho. Go watch it. All right. Sir, no time to watch anything, sir. No problem. I'm more than happy for you guys then. Now coming back to the point, in a situation where a person himself is a 12th background, 12th dropout, is teaching the largest crowd in the country right now in the name of a company called Physics Wala. Do you know it's listed?
Yes, sir.
Do you know it has gone ahead and got a highest stake? Do you know the person who started? All right, Alak Pandey. He himself is 12th dropout. I'm not inspiring you guys to drop out now. I'm just saying that things can plan the way it is as long as you have the perseverance and consistency. Look at it. Some person who was teaching, do you know the setup? All right. It's not because of the series that I know him. All right. I've gone through a lot about him. Do you know he used to have a phone, the phone which you're using right now to record his videos to post it on YouTube? All right. That's when his journey started. And apparently, a lot of people coming from a very downtrodden background where they are not able to afford NEET exams. What are NEET exams? Those which are written for your MBBS entrance. Those exams which are written, your CET exams, which are written for IIT exams. All right. People pursue all of these. The fee structure, do you know? 1 lakh, 2 lakhs, 2.5 lakhs. That is just the coaching fees. I hope I'm loud and clear. Everyone understanding? So this guy started with his own thought process that I don't want to spend so much. I don't want students who are poor to miss out on the opportunity. And he started charging 3,000, 4,000 for the entire course. He realized that with this 3,000, 4,000, 100%, I will not be able to sail through because the cost of the teachers, the cost of the setup, the cost of entire operation is expensive. So what did he do? Increase the fees? No. Went to the public, raised money, used that money for the purpose of teaching. Are you understanding? Public offers. Connecting everyone with me? Next thing, Dhirubhai Ambani. All right, one of the most inspiring characters that you can have in India. Person 10th dropout. I think he was a school dropout. He was 8th dropout, not even 10th dropout. And built the biggest empire of the country, Asia, Fortune 500 company. Who is he? 8th standard dropout. Each one of us have 1,000 things to do. We are just stuck with Instagram reels. That is our problem. All right. Please get out of it. Life is much more than what you see right now around you, and you have the capability. Those of you are doubting, sir, how will I do it, sir? I don't have the caliber. How did an 8th standard dropout do it? How did a 12th standard dropout do it? I don't think you are in the worst case. It's just that consistency and perseverance. That's it. Nothing else. Nothing else. It's not that they were lucky. No, they got lucky because of their hard work. Coming back to the point. What is with this guy, Dhirubhai Ambani, sir? Dhirubhai Ambani, when he started, all right, he raised money through all the possible things. But one fine day, he realized that I can't survive with small funds. I want to raise big money. And that big money is through the public offer. This is the introduction to the chapter called Prospectus and your allotment of securities. Is the screen visible to everyone? Yes?
sir.
Let's
No.
get started. Let's get started. Those of you saying yes, whose screen are you seeing? I don't know. Let me go ahead and share my screen right now. Please keep your cameras on, 100% focus. One of the most interesting topics because practically we connect with what we are having right now. The first topic, or what is this topic all about? By the way, what is the importance of this topic? This is going to be a part of a bucket. Is the screen visible, everyone?
Yes, sir.
Yes. So this is going to be, the chapter is called Prospectus and Incorporation and Allotment of Securities, not Incorporation. This is going to be the bucket which is going to fetch 20 to 30%. If you remember, of 70 marks, 20 to 30% comes from this bucket. Now in that bucket, there is a chapter called Prospectus and Allotment of Securities. Sit straight, everyone. What are we learning? Section 23 is saying, sir, how to beg, borrow, steal. That's exactly what section 23 is saying. If you are a public company, how to beg and how to raise your money. All right, it's nothing wrong when I say begging. Huh? Those of you getting carried away, it's nothing wrong. It's just to see how do I raise money for expansions. That's the need of our. And if I'm a private company, how can I go ahead and raise money? That is what is covered. Both of these are covered under section 23. Everyone with me? Yes. So section 23 says, if you're a public company, you can raise money in 3 ways. If you're a public company, Aparna, focus, everyone. If you're a public company, I can raise money in 3 ways. The first one, issue of prospectus. Second one, private placement. Third one, Asha, right issue and bonus issue. When I'm a private company, how can I raise money? I can do private placement, right issue and bonus issue. Why not prospectus? Why not prospectus?
They cannot collect from public.
Where is it coming from? Why it cannot collect? Section 2, clause 68, prohibition, RLP. Connecting dots. Therefore, if you see the inconsistency between these two buckets is nothing but issue of prospectus, because this I cannot do it. Clear? So section 23 is the first section which talks about how to raise money and how will you go about with it. Understanding, everyone? All right. So section 23, let us start. Public offer and private placement. Section 23 says, sir, if you are a public company, you can raise money by public offers. You can raise money through private placement. You can raise money through right issue. You can raise money through bonus issue. You don't break your head. I will explain each of this. You just be with me. What is right issue? What is bonus issue? What is private placement? I will explain. You just be with me. If you're a private company, Nagratna, private placement, right issue, bonus issue. I cannot do anything else. I cannot go to the public offer. Why? Prohibition. Prithvi, where we are prohibited from going to the public straight away. Sudarshan, understanding? Srikar there with me? Yes. Suhas, Santosh. Next, public offer is the word that you've used. Now, what is this public offer, sir? Sit straight. If I want to go ahead and make a public offer, clauses, I will show you 3 ways of making public offer. Sit straight, everyone. I will show you 3 ways of making public offer. The first one, Vatsal, is called IPO. Second one is called FPO. The third one is called OFS. What is IPO? First time begging. Initial public offer. Now, I liked begging so much that I want to go ahead and beg once more. That is called follow-on public offer. Did you understand? Both of these points are clear. All right. The first one is called IPO, initial public offer. For the first time when a company goes ahead and issues its shares to the public, inviting public to buy its shares, it's called as IPO, initial public offer. Second time when I go ahead once again raise money from the public by issuing shares, it's called FPO, follow-on public offer. Shares there in the session. The third category is called OFS. Now, what is this OFS, sir? Offer for securities or offer for sale. Sit straight, offer of securities, offer for sale. Now, what is this? Let's suppose Tilak, all right, and Nagashri, both of you there in the session, both of you have gone ahead, built one of the biggest artificial intelligence companies in the world. There are 2 right now. OpenAI with me, and the other one is called Claude. Not sure how many of you are aware of it. In India, it's Perplexity. Perplexity is the biggest AI company in India. Not sure how many of you are aware. Now, let's suppose our folks, our friends have gone ahead and started even bigger than OpenAI. They're saying that all that OpenAI and all is closed. We are doing much better and bigger. So these guys have gone ahead, started their company. For the first time when they go ahead, issue new shares, it's called IPO. For the second time when they go ahead and issue new shares, it's called FPO. OFS is where Nagashree says, sir, now I'm tired of coding. I want to go back to CA. She wants to sell her shares to the public in the market. But the problem is, the moment Nagashree sells her shares in the market, don't you think people will have a wrong image? Why is the founder selling? Why is the promoter selling? Is there something wrong? Is there something going, something missing? All of these kind of questions will start coming in the market. So what Nagashree can do, instead of selling it in the market as is, she will bundle it and sell it more like a public offer, inviting public to come subscribe to the shares. This is called OFS. These are not new shares. IPO and FPO are new shares. OFS are not new shares. It is the promoter's shares which are being sold. No new shares are coming into picture. Understanding, everyone? Clear? All right. Now the question is, why, sir, she can go ahead and sell it in the market? No. What will happen? Nothing will happen. The market will crash. Her stock prices will crash. Why? Lower the demand. Demand remains the same. Higher the supply. Basic economics that I've learned. Demand remains the same. Higher the supply, prices fall. This is exactly what will happen if Nagashree goes ahead and offloads it in the market as is. So that's why what she does, I will not offload it in the market as is. I will take a bunch of it. I will offer it as public offer, inviting public to tell me how much are they ready to pay. What is the entire concept of public offer? We will see in length in the next session. This is how OFS is how promoters get an exit from their company. You might have seen Shark Tank. All right. Do you think these sharks who are investing, will they be in the company forever? Nothing doing. They are there for 2-3 years. The company expands. They become big. They sell their shares and move out. If it is a bigger chunk, they can't sell it in the market. So they will go ahead with OFS. Promoters exit. Connecting everyone in detail. We take more of live examples to discuss this topic in the next session. See you guys. Thank you so much. Have a nice day.
Thank you, sir.
Thank you,
Yes,
sir.
sir.